Well, good afternoon. This is John Mazzara with Remax Results. And today I have a special guest. Thank you for visiting my channel. It's Gregory Singleton with Signature Law PLLC. And we're going to talk today about real estate and estate planning. He's one of the premier attorneys within the Twin Cities, and he's gracious enough to share some information with us all today. And feel free to reach out to him post video and schedule a time to meet, and he'd love to take care of all of your legal needs. So with that, Gregory, tell us a little bit about what people might want to consider with regard that they maybe hadn't thought about with regards to real estate in their estate planning.
Yeah, I think the big one, the big question in estate planning is probate. Um, if you're not aware, probate is the court process by which though whoever your personal representative or executor is, takes your estate to court, gets judge's approval on everything that you want to distribute, or that's in your estate that needs to be distributed. The judge gives its blessing, and then it finally gets distributed, which doesn't sound so bad, but it takes about 10 to 12 months, and it's a big headache, and it can cost upwards of five to $10,000, depending on the complexity of the estate. So it's something we like to avoid. And one of the biggest things we want to deal with to avoid probate is your real estate. Um, you only go to probate if you have an estate that has $75,000 in probate assets. And a probate asset is one that does not have a beneficiary on it, and two that you own outright, which gives us two different strategies, a beneficiary strategy and an ownership strategy. The one that people don't think about is the beneficiary strategy. And this one, a lot of estate planners don't actually tell you about just because it's less expensive and it's easier to do for some reason. With the beneficiary strategy, what you're going to use is what's called a transfer on death deed. And what this does is it's basically a rider that attaches to the existing deed and appoints a beneficiary, such as your kids, to your house so that when you die or you and your spouse have passed, the property goes to your kids or to one of your kids or to a friend or whomever you want it to go to. It's a real slick way. They're very inexpensive. And with the beneficiary strategy, let's say you're a retiree and you don't have a lot of assets. Maybe you have a retirement account, a bank account, and your house. Once you slap that beneficiary on the house with the transfer on death deed, then you just got to contact the bank and your financial institution. All of a sudden, you're avoiding probate, and you don't have to go through all the expensive revocable trust and everything. Um, the other approach is called the ownership strategy, or I call it the ownership strategy, and that's using a revocable living trust. And a lot of people watching this may have heard about revocable living trusts. There's a lot of misconceptions about what they can do and what they can't do. To just explain what they are, I'll give you two definitions. One is compared to a will. A will is a legal document that says where your stuff goes when you die. It's that simple. A revocable living trust is a much thicker document that says where your stuff goes when you die, and it's on steroids, so it can do a few extra things. To explain really what a revocable trust is think of it like a big box, a magical, mystical box you put in front of you. And while you're alive, you put all your stuff in the box. While your stuff is in the box owns it legally. You technically do not own it. You have full control over the box. You own the box, but you don't own the stuff in the box. So what happens is because you don't own the stuff in the box and you put everything you own in the box, when you die, you don't own anything. And you don't have $75,000 in probate assets. Therefore, the box closes. The instructions written on the outside of the box of where to ship stuff to, just like a will, distributes everything. You can be done in a week, or sometimes a little bit longer, depending on the situation. But it's a slick way to deal with it. For houses, we deed the property right into the trust. The trust owns the property, and it takes care of probate for you. That's
Interesting. No.
yeah,
What about
that's
somebody that has credit card debt? How are so people have asked me that before, and I'm like, well, I'm not really exactly sure. Or if they own a timeshare. So, or how are those addressable with regards to probate or somebody dying?
So credit card debt, if you are the only signer on the account or on the only one that owns a credit card, when you die, your estate will have to satisfy that debt. So it'll pay out of the estate. There are such things as exempt assets, such as your house. Creditors, when you die, if it's a homesteaded property and it is going to your spouse or your children, the creditors cannot go after those assets, cannot go after the house. So if your only asset is your house plus some credit card debt, which would be a liability, the creditors can't try to satisfy the credit card with the assets in the house. Um, Timeshares is a beast and the thorn in my side. They are treated differently in every state, and they are treated differently within the state depending on the person that you have the timeshare with. Sometimes it's a legal or a land, it's considered a land contract. Sometimes it's just considered an operations contract. And there's various implications for whichever one. The challenge is getting out of town timeshares because in my experience, most kids don't want to take over their parents' timeshare. There's a lot of expenses, they're not going to use it, and it causes me unbelievable amounts of headache to try to transfer timeshares. In fact, to this day, I was working with I won't say the name of the company, but they're a Florida resort company. I worked with them to transfer a timeshare. It took forever. And I still to this day get a monthly call from them telling me that my timeshare shares aren't being used. I don't have a timeshare with them, but they got my name on my list. They refuse to remove it. I have spent a lot of time doing it. So there's a lot of problems with timeshares. They're the thorn in my side, definitely.
Funny. Okay. Well, how about some people own property, let's say in South Dakota or Wisconsin or Iowa, one of the adjacent states, and what should they consider doing as far as an estate, so that they don't have to necessarily do probate in two states, or that they can avoid it and make it easy as far as a transfer. Would that be a TOD, a transfer on death deed in those states, or is it only recognized in Minnesota?
Yeah, it depends. It depends on the state. And that, first of all, that's an excellent point to bring up. If you have real estate that is into multiple states, like you have a cabin in Wisconsin and you got some hunting property in in Montana and your house in Minnesota, we're looking at three probates. Two of them are what we call ancillary probates for the where you don't have a homestead or you don't reside. But that's three probates. That's three attorneys you're going to have to hire probably, and that's a whole heck of a headache that you don't want to deal with. So, especially if you have property in other states, you really want to take care of it and get that plan going. For as far as transfer on death deeds go, that's a state statute that authorizes a transfer on death deed. I'm unaware of any state that doesn't have it. That's not saying that they don't, but all the states that I've interacted with have some form of transfer on death deed. They may be called something different, like Florida calls it a ladybird deed.
Hmm.
Um, Essentially the same thing. It has the same effect, but there are different regulations for each. If you have a property in another state, you can put it into a Minnesota revocable trust. So
Okay.
you can use either strategy. There's going to be some reasons why you might pick one strategy over the other. But I won't go into the litany of reasons. But
Sure.
yeah, there's you can probably do both strategies depending on the state.
Okay, and what about if you own something internationally? Let's say Canada or Mexico or Europe or something. I don't even know how often you even run into that, but what about that?
Yeah, that's a tricky one. It's a totally different jurisdiction. There is the International Conference on Will. I think it's called the International Conference on Wills. I believe there are 13 countries that are parties to. It's been a while since I've looked at this, but 13 countries that are party to it. And what the Conference on Wills says is that if you properly execute your will in one of the countries, it will be recognized in the other country. Um, I want to say Italy is one of them because I was working with a couple that moved to Italy. There are some
Hmm.
documents you have to fill out and properly execute, make sure they're done right. The challenge is we're looking at a probate in another country if we have real estate in another country. And it's not all countries recognize trust law. May not recognize revocable trust at all. So you can't just put, if you have real estate in Russia, you probably can't put it in your revocable trust in Minnesota. It's not going to
Hmm.
work. So you're going to have to contact an attorney in that country to make sure you get all the T's dotted and the I's crossed.
Wow. Sounds like more work than I'd want to do.
It's a lot. It can be a lot of work. It really can be a lot of work. And if you're born in another country, there's a whole bunch of things you have to do in probate. Yeah, once you get international, it starts getting more complicated.
Wow. Okay, well, hopefully that's just an outlier for people watching this. But if somebody did have a question about any of these topics, you sound very well versed in them, and you'd be either be able to answer the question or direct them to somebody that could.
It's all I do all day, every day. So,
Okay.
but I
Awesome.
learn
Awesome.
something new every day. It's a complicated area of law. So,
Awesome. Well, I know some people have set up cabin trusts in Minnesota.
mhm.
What do you think of that? And can you shed any light on that?
Yeah. So what we use cabin trust for are basically transferring the cabin from one generation to the next and trying to make sure that the cabin is used by the family and available for the family from generation to generation to generation. There's two ways to do it essentially. One is using a cabin trust, which is a totally separate, it's a revocable trust during the lives of the settlers, the people who create the trust, like your parents. And then when they die, it becomes irrevocable. And the terms of the trust say, here's who's going to manage the trust, here's who's going to do this and that, the other thing. The other way to do it is with an LLC. I guess you could do it with a corporation, but that doesn't make any sense. So people do an LLC. That's become less popular just because of some of the recent laws that have been passed and then revoked the beneficial owner reporting requirements that are no longer necessary, but we'll see what happens in the future. Um, the great thing about those trusts is if you just have joint ownership, let's say mom and dad passed it to three siblings. If they were just to deed the property over to the three siblings, we're going to lose a step up in basis, which is a tax benefit that you want to get at someone's death. B, it's just going to be joint ownership. And if someone wants to sell out, let's say one of the siblings moves to New York, they don't necessarily want to have ownership in a Minnesota or Wisconsin cabin. So they're going to want to get out so they don't have to pay property taxes and maintenance and everything like that. If you just deed the property directly to them, we're going to have some problems because then we're going to get into mediation, possibly even litigation to figure out how we're going to divide that property, who's going to buy out who, et cetera, et cetera, et cetera. With a trust, you can put in a lot of provisions. That's kind of the Wild West. You're creating law when you're writing contracts and trust. That's kind of what I like, what I do. You're creating law for the parties that are at issue. You can put in there things like a common one is if someone wants to make sure that they don't sell the property just to make money, put in a provision that says if one of the three siblings wants out, first of all, the other two siblings have a right of first refusal. And the property can only be sold to family members, and you put transfer provisions in there so it can't be transferred out of the just to some random guy that lives in Wisconsin or whatever. Second, you can say, let's see, the property, if you want out within the first 10 years, the property will be, the fair market value will be established as the fair market value as of the date of death. And the reason you do that, so the property increases in value over time. Someone says, ooh, the market just spiked. I'm going to sell and establish the fair market value by a new appraisal. Now my brothers and sisters have to pay me money. Mom and dad can say, I want that money, it's more important for the cabin to stay in the family. So we're going to set the fair market value here, or maybe even just a 10% discount. It's a disincentive to sell just for the money.
Good idea. Okay. So if somebody watching this has a will or a trust or hasn't done anything, nobody gets out alive. So I'm gonna, we got to acknowledge that and get our house in
Yep.
order at some point. Or the state will do it for them, correct? I mean, you'll have interstate, and then that may not be what people want. But I'll let you address if you choose as a watcher of this video to do nothing. I'll let Greg tell you what's going to happen to you. But
Yeah. Yeah, if you don't do anything, well, if you don't write a will, the state has written one for you. It's called the intestacy statutes of Minnesota. And there, the basically the law says that your all your property goes to your spouse, and there's some nuances in there. But then if you don't have a spouse, it goes to your kids, and then grandkids, then parents, brothers, sisters, nieces, and nephews, et cetera, et cetera, et cetera. The famous classic case on this is Jimi Hendrix.
Hmm,
He didn't have a will, and he died of what I've been told is an alleged overdose of drugs shortly after releasing Purple Haze, or at
hmm,
least it was in the process of being released. Now, Purple Haze was worth a lot of money to the Hendrix estate. He didn't have a will. What Jimmy did have, and he didn't have a spouse and didn't have kids that we know of, but what Jimi Hendrix did have was an estranged father that he hadn't seen since, I don't know, since he was a toddler, in
hmm,
fact. Everyone assumed that if Jimmy had written a will, he would have given everything to his best friend. He didn't write a will. So everything went to his estranged father that he may not have even remembered in his adult lifetime.
hmm.
That case was in litigation back and forth for 25 years or
Oh
more
my
than
God.
25 years. As people fought over the estate, and then the estate transferred to the daughters of people, and et cetera, et cetera,
Hmm,
that were barely related to Jimmy. The real big challenge is the courts see those laws of intestacy as absolute. You can't walk in there, for instance, let's say you never got married, and but you have a life partner. You've been together 30 years. You own a house together. One's got a cabin. It's a bunch of assets everywhere, left and right. You don't do beneficiaries. You die. You'd hope that the person that's surviving would be taken care of by the decedent's assets. But if they're not married and they don't have anything, then all of a sudden they're not in the order of intestacy. And you could bring 50 people to the courtroom and everyone could testify. We even thought they were married. They acted like they're married. They wanted this. The judge would say, well, they didn't write a will and didn't do a trust, so they obviously didn't want it that much. And that's kind of a scary situation. And it's unfortunate, but it's also, I mean, it's there to prevent fraud in many way cases, because there's a lot of fraud that happens in probate or is attempted in probate, mainly
hmm.
because there's a lot of money at issue and the main witness is deceased. So you can try to get away with a lot.
True.
So yeah, if you don't do any planning, it's gonna go to someone. You may have an estranged son you haven't seen in 20 years, and you don't like them because of this, that, and the other thing. They're still getting a chunkier estate if everything's going to the kids.
Hmm. And so there is no common law. Like people sometimes say, well, I've been with them, so I'm legally married through common law or something like that. Minnesota doesn't have anything like that that they
Minnesota
could
doesn't
become.
recognize it. I don't believe there's any other state that still recognizes common law marriage, or
Okay.
a newly established common law marriage. I could be wrong on that, but I believe the answer is there is no state that recognizes common law marriage.
Okay, at least we know Minnesota doesn't.
Or Minnesota certainly doesn't. Minnesota certainly doesn't.
Okay, so Minnesota does not recognize it, correct?
That's correct.
Yeah,
That's correct.
okay, perfect. So somebody that's hanging out thinking that their significant other is going to get it, if they don't do some legal planning, really isn't going to get it.
Yeah. No.
They're not beneficiary, they're SOL.
Yeah, I've seen people crushed by that realization after someone died, and it's heartbreaking because it's not right, but what can you do?
Right? What about somebody that may have done estate planning 20 years ago when the estate exemption, was $600,000 and they did the AB trust and they go like, well, I did that a long time ago. I don't need to do it. And they die with that structure in place. And today, it's much different. It was the exemption amount, federal and state. What happens in that situation?
Well, so what you're talking about for the exemption is the estate tax exemption. And
Mhm.
in Minnesota, you don't have to pay estate taxes until your estate is worth $3 million or more. It used to be much lower in the 90s. It was under 100,000, under 1 million,
Mhm.
around 600,000 in 95, I believe. And on the federal level, it's 13.99 million. Next year, it'll be 15 million, a dollar exemption. So not a lot of people hit that. I curse all of my clients saying, I hope you get hit with a federal estate tax. Your estate
Right.
does. I curse everyone that way. But um, what if they did what you referred to as an AB plan? That is one way of uh, so, so in Minnesota, if you're married, you've got your $3 million exemption, and your spouse has a $3 million exemption. If you do proper planning, you can do it to turn it into a combined $6 million exemption with proper planning. And an AB plan is one way of doing that.
Mhm.
If you had a plan that was done in the 90s, it should be still good. Now, there will be some nuances if you're using testamentary trusts, and that's where you have the revocable trust as like an umbrella. And then when you die, certain trusts come into existence, such as to manage assets for your children, or for someone with a compulsive behavior problem, or for someone that's on
Mhm.
medical assistance. Those laws have changed dramatically with the Secure Act that was effective January 1st, 2020. That upended all of trust law, or at least for putting qualified retirement assets into a trust. Changes things dramatically. So if you tried to do that and you have a very old trust, you might have a problem now, or at least you might have to end up in court to change the trust or decant the trust into a new trust that comports with the law. But technically, it's still good if it's even if it's 30 years old, as long as you haven't rescinded it.
Okay. And the last one supersedes any previous one, correct? So if somebody came and saw you tomorrow and they did something 30 years ago, the current one, once it's signed and stamped, that's the official one, correct? They can't go back and say, well, we want to use the old one. How do we make sure that the old one is dead, if you will, or extinguished?
Yeah, that's a great question. Technically, not necessarily. You should have a rescission clause, and every will that I've ever seen has a rescission clause that says this is the latest and greatest will. Every other will and codicil, which is an amendment to a will, has is superseded by this will and null and void. And trusts do the same thing. Now, let's talk wills for a bit because it's a little bit easier. Trust gets a little bit more complicated. Um, what you don't want to have happen is, let's say you've got two wills. One gives your first will from 1990 gives half your assets to Bob and half your assets to Sue. Somewhere in the early 2000s, Bob gave you the stink eye, and you wanted to cut him out. So you make a new will and say, I'm going to give everything to Susan and not give anything to Bob.
Mm-hmm.
What happens is Bob doesn't like that. He wants the original will. So he could, let's say he was the one that was the caretaker of the will or knew where it was and wanted to commit fraud. He could get rid of that will, throw it out. The legal presumption is that will doesn't exist. All of a sudden, that old will comes back into play. Unless you do the smart thing, which is go to your old will, write void on it, or rip it up, or burn it up, or shred it. That's enough to, just have to show that you want to rescind it by some action, and that rescinds the will. Um, the second thing you want to do is make sure Bob doesn't have access to that will. That's that's a big one. Um,
Mm-hmm.
but but then there's the other side of it. If we get rid of this old will from 1990, cut Bob out. Let's say Bob and Susan are our kids. And then we have a new will that disinherits Bob. Well, let's say that will is fraudulently wanders off into the ether somewhere. All of a sudden now we're dropping back to the laws of intestacy, and Bob's going to get half if there's no spouse involved. So there's a get your will, put it in a very safe spot. We don't want copies floating around. I'm going to say that again. Do not make copies and send them out to all your friends, because that can create a lot of problems down the road.
Great idea. You as the attorney, do you keep a copy so that if somebody said, well, and is that a legal copy? So let's say they didn't have a safety deposit box and they kept it in their closet and then they had a house fire and maybe they died in the house fire. So the will is burnt up. Do you as an attorney have a copy? So like, yeah, I think Gregory was his attorney. Let's see if he's got something that we can work with. Does that happen?
Yeah, it does. It does. And that's that situation. It happens. We like to put things in fireproof safes. We used to put things in refrigerators because they used to be fireproof. They are no longer fireproof. So don't stick your legal documents in your refrigerator. But I keep a copy. I actually keep a copy that I can edit. So if someone wants to make a change down the road, it's real easy. They come in, they say, I just want to change my personal representative and take Bob out of the will. Well, I can just do that real quick. I bill by the hour for that, and I'm usually done in about 5 minutes. So it's not a money maker for me, but I always
Sure.
have that. We can
Nice.
probate a lot. If you've lost the will and you got a copy of it that's executed, you can probate that copy. It's not always easy, but you can do an affidavit of lost will, and you can push that through the courts. We've done that recently, many times, actually.
Okay, interesting. Wow. Well, it's obvious that you kind of know your stuff, just a little bit. You
It's
sound
all.
like quite the expert. So, if somebody is watching this and wanted to set up an appointment to come in and see you, what would be the process to do that?
Yep. The easiest way is just go to our website at signaturelawpllc.com.
Okay.
And you can sign up for an appointment right there. We do an initial consultation for free. I don't believe in nickel and diming people for no good reason. We can do that over the phone, over Zoom, or you can come in person. Or if you are homebound, sometimes we can even come out to you.
Okay.
Our offices currently for the next month are in Plymouth, but as of November 1st, we're moving down to Wayzata, 5 minutes away. But yeah, what we take consultations over Zoom phone, in person, and the easiest way is just either pick up the phone, give me a call, and we'll get something on the calendar, or you can sign up right on the website.
Wow. Well, that sounds great. And I assume you also, as part of it, you do the ancillary forms like the healthcare directives and the power of
Oh yeah.
attorneys as part of it. So,
Yeah, absolutely. We do it as a package. We
okay.
do the will, the trust, all the supporting documents for that, the healthcare directive, power of attorney, a number of other authorization documents. We also give you a binder that has a number of worksheets that say where you put your debt, where's your debt, where's your assets, where's your digital assets, what's your funeral directive. Basically, we collect all the information that is needed to make the estate administration process as easy as possible. Put it all in one spot, put instructions on everything so that when you die, it's a real gift for the people you leave behind that have to administer your estate. They just go to page one and it says, do this, and they do that. And they go to page two, they do this, they do that.
That sounds perfect. Well, that sounds like a great thing. Greg, thank you for coming on today. Everybody, I recommend that you give him a call and get your house in order because nobody gets out alive. So,
Thanks, John. I really appreciate it.
you bet. Thanks for coming today.